5 seconds to go. Start. Sridharan further submitted that the Sikkim High Court has only relied on the judgment of this court in the case of Union of India and another versus VVF Limited and another. He submitted that the issue in the case of VVF Limited and another Supra was with regard to the withdrawal of notification since it was found to be misused. He submits that the factual situation in the present case is different and as such the High Court was in error in dismissing the writ petition. Shri N. Venkataraman, Learned Additional Solicitor General ASG for short, on the contrary submits that promissory estoppel cannot be applied to the representation made by the Union of India if there is a material change in the circumstances and the larger public interest warrants such a withdrawal. He submits that in view of the constitutional amendment, a new era of GST has emerged. He submits that the new era emphasizes on the principle of pooled sovereignty where states and centre share equal responsibilities. Learned ASG submits that Article 279A of the Constitution provides for the establishment of the GST Council. It is submitted that the GST Council consists of the Union Finance Minister, the Union Minister of State in charge of Revenue or Finance, and the Minister in charge of Finance or Taxation, or any other minister nominated by each state government. He submits that the GST Council has been empowered to make recommendations to the Union and the states on the taxes, cesses, and surcharges levied by the Union, the states, and the local bodies which are to be subsumed in the GST. It is submitted that Clause 6 of Article 279A of the Constitution of India directs the GST Council to be guided by the need for a harmonized structure of GST and the development of a harmonized national market for goods and services while discharging its functions. He submits that under Clause 1 of Article 246A of the Constitution, both the Parliament as well as the state legislatures have been empowered to make laws with respect to GST to be imposed by the Union or by such states, whereas Clause 2 of the said article empowers Parliament to make laws with respect to GST where the supply of goods or of services or both takes place in the course of interstate trade or commerce. Learned ASG would therefore submit that a sea change has occurred with the advent of GST from 1st July 2017. The first change in the submission of the Learned ASG is that the earlier tax regime was origin based, whereas the new tax regime is destination based. Under the old regime, the centre was collecting 100% excise duty, service tax, central sales tax, etc., and the states were collecting 100% value added tax, VAT for short. Under the old tax regime, there was no uniformity with regard to state levies, whereas under the new tax regime, there is uniformity. Under the new regime, both Union and the states come on the same platform under Articles 246A and 279A of the Constitution and become common partners for taxing together. Under the new regime, both states as well as Union charge at the same rate. Learned ASG submits that the only common feature in the old regime as well as in the new regime is that the centre continues to fund the states. Learned ASG further submitted that pursuant to the enactment of GST, a notification being notification number 21 of 2017 was issued on 18th July 2017, thereby withdrawing the exemptions granted previously under the erstwhile excise regime. He submits that the appellants have not challenged the validity of the said notification. He further submits that, in view of the proviso to clause C of subsection 2 of section 174 of the CGST Act, the exemptions stood automatically rescinded. The validity thereof has also not been challenged by the appellants. He therefore submits that the writ petitions, without challenging the validity thereof, are not tenable. Learned ASG submits that though after the enactment of the GST, the central government was not bound to continue granting any relief, however, as a matter of good gesture and on the recommendations of the GST Council, it has decided to reimburse 58% of CGST paid by such industrial units who are entitled to the benefit of exemption notifications. He submits that the said has been done based on the recommendations of the Finance Commission, which has earmarked the share of the Union at 58% and of the states at 42%. Learned ASG submits that the writ petitions have been erroneously filed seeking a relief against the Union. He submits that if the appellants have any claim, then that would be against the state governments wherein the industries are situated. It is submitted that, as a matter of fact, the government of Jammu and Kashmir, by notification dated 21st December 2017, has already resolved to reimburse the remaining 42% of the GST to the units located in the state till the period the union scheme is implemented. Stop.